Hello, everyone, and welcome to Franz's Real Estate Facts, episode lucky number 13. That means that my podcast is a teenager, which hopefully means that it will not go through like some neurotic self-identity crisis that teenagers normally go through. Um, but in order to mark this moment, and also because I think Alanna Pearl is really amazing and I love talking to her, I have brought her back to talk to us a little bit about the difference between wills and trusts and, everything in between. And also, as a second piece, one of our viewers actually reached out to me and said, "Hey, can you have somebody come and talk about this?" So, for anybody who is watching the show and feels like they have something they want to hear about, I am happy to take your requests and find guests who are able to accommodate and answer your questions. So, Alanna, thank you so very much for being with us. I am really appreciative of your time and your willingness to be here a second time. And yeah, so we're going to talk about wills and trusts and, estate planning and all of those things. So,
Let's do it.
yeah, so let's do it exactly. So I guess the first question is, I hear a lot of people, in my industry and, just people in the general public, and they say, I have a will. And I'm like, oh, you should have a trust. And they're like, oh, but I have a will. And I'm like, you should have an estate plan. And they're like, I have a trust. So are those three things the same thing or not? Or how does that work?
Yeah, let's break it down. So, a will can be part of an estate plan. A trust can also be part of an estate plan, and you may have both a will and a trust as part of your estate plan. And at its core, estate planning is the process of turning your wishes and your desires into legal directives and making sure that you have all the documents you need as part of that plan so that everything would happen the way you want, that preferably your family would stay out of the court process if that's a goal of yours, that the right people would be making decisions for you in the event of your incapacity, that they would be able to access your assets in the event of your incapacity, and of course, that your assets would pass to the people you want in the way that you want in the event of your death. So, a will is essentially that we have a phrase in the estate planning world that where there's a will, there's a probate. So most people understand what a will is because, we've all heard of this. And a will is your instructions for what happens to everything that you own in the event of your death, who it goes to and how. But the thing about a will is that in most circumstances, a will has to be interpreted by a judge, which means that somebody has to take your will and take it to court and say, hey, judge, this person has passed away and this is their will. And there's a very long, expensive process that happens from there called probate. And essentially, at the end of the day, it can cost about, on average, 5% of the gross value of everything you own, which is not that appealing to many people. But it's a public process. Everything that you have is on public record, and it's a very long process. There's a lot of red tape. There's a lot of things that have to happen. Notice has to be sent to all your creditors. The judge has to approve everything. And so most people, once they realize that that is the default system, that's what's going to occur if they don't opt their family out of it, they want to find a way to avoid probate. And a will does not avoid probate. So there are some situations where you could have just a will and your assets, your estate would not have to go through probate. And the main one is that if your assets are under the limit for probate. So if the total value of all your assets is less than, it's about $165,000 currently in California,
Mhm.
then your assets, the person that you've designated as your representative will not have to open up a full probate. There's a shortened procedure for them to transfer your assets to the people that you've said. So that's one circumstance where you may not need something to avoid probate. If the total value of your estate is less than around $165,000. And you don't own any real estate, because if you own real estate that's more valuable than $50,000, which is essentially every piece of real estate in California, very few pieces of, maybe you own a small plot of land somewhere. That's pretty much the only way that maybe it's going to be less than 50,000. But if you own property, then you probably don't want that property, even if it's just your primary residence, probably don't want it tied up in an 18-month court process just to get to the people that you love in the event of your death. So
Right.
if you own real property in California, you're probably going to want to look into having what's known as a living trust. And a living trust is basically a will substitute. And it does a lot of the same things as a will. It
Mm.
says who you want to receive your stuff if something happens to you, but it actually does a lot more than that. It makes the whole affair a private affair. So it takes that whole process out of court, and during your life, you create, well, I like to call a trust, it's kind of like a little red wagon, right? This is the analogy I use a lot. So it's like a little red wagon, and you create this little red wagon, and you can make it really shiny with all kinds of different features, but it could be simple or it can be more complex. But once you have that wagon, then you put all your stuff in it. So you put the title to your house and your bank accounts and your business and any other stuff that you own. You put it all into that wagon, one after another. And that's a really crucial part of estate planning. It's a part that a lot of people miss. It's a part that a lot of lawyers, they drop the ball, unfortunately, on, because if you have a little red wagon, that's great. But if it's an empty wagon, it's not really doing very much for you. So you got to make sure you
Right.
take the next step and put all your stuff in that wagon. But once
Right.
everything is in that wagon, and you might even make the wagon the beneficiary of life insurance policies that you have, especially if you have minor children, because what
Mhm.
that means is that in the event of your death, the death benefit is going to be put into that wagon, and you're not around anymore. So you're not there to be, pulling the wagon behind you by the handle, but you've already named the person that is. And that person is called the successor trustee of your trust. And they step into your shoes in the event of your incapacity or your death. And they read the playbook that you've left, which is the trust agreement. And they say, okay, well, this is what Mickey Mouse has told us to do, and so we're going to honor that and administer the trust, the wagon, in the way that you've said. So that might mean keeping some of the stuff in the wagon and using it for the benefit of minor children. It might mean taking stuff out of the wagon and giving it to different people. It might mean keeping it in the wagon for a while and then taking it out. It could be all kinds of things. So that's the decisions that you've made ahead of time. You've put it into your trust agreement. And then you know that this whole process is already planned out. And most importantly, it's going to happen privately outside of court, because you don't have to sign any documents to transfer your assets to anyone. You've already done it. You've transferred the assets to your trust, to your wagon. So we don't need to have a judge step in and substitute his or her signature for yours, since you're not here anymore. We've already done this all ahead of time. So that's the difference between a will and a trust. Ultimately, at the end of the day, they provide a lot of the same features or benefits, but a trust is going to have a lot more benefit if your estate would otherwise have to go through probate. It's a way to completely avoid probate, and it's a way to make sure that there is already a mechanism in place to take care of minor children in the event of your death without having to drag that whole process into court.
Right. And I think so. Thank you for that very clear explanation. And I also think that one thing that's really that you said really kind of in passing, but I think it's really important for people to hear, is it is the gross value. So if you own a $5 million house in La Jolla and there is $5 million worth of mortgage on the property, you have $0 of equity. But for probate purposes, you have $5 million worth of stuff. And when you say it's going to be 5% of the gross value of the asset, then you're going to be paying 5% of $5 million, which is $250,000. And you're going to have to figure out some way of coming up with $250,000,
Yeah,
right?
your
So it's
heirs
important
will,
to
right?
understand.
Yeah.
Yes,
Yeah.
your heirs will need to come up with a way to come up with with $250,000. So, and if it goes to probate, that's what happens. So it's really important for people to understand that it is gross value. Just because you have no equity does not mean that the government and the state and all of these other people don't think that you have assets and money to pay them to do things.
Yeah, and a big chunk of that 5%. So when I say 5%, what I'm referring to is the average cost all in of a probate in California. So sometimes it's less, sometimes it's much more if it's a complicated probate. It's not a set amount, but what goes into that are all different types of costs and fees, including a big chunk of it is the attorney's fees, because the attorney's fees are set by statute. And so the attorney's fees, the attorney is entitled to receive a fee based on, like you said, the gross value of the entire estate. So that can end up being a big chunk of money. And then there's a lot of other costs and fees associated with a probate, and it can get very expensive, especially if it's anything other than just a very simple and basic, straightforward probate, which even the most simple and basic and straightforward probates, by the way, aren't that simple and basic. It's very complicated. And from experience, I'll tell you, it's not something you want to leave your family with. It's something that you can opt out of. It is the default system, but it is not the required system. And with just a little pre-planning ahead of time, if you are somebody that, it really would be in your family's best interest to set up a living trust ahead of time, it's not hard to do. It's not that expensive, relatively speaking, compared to the costs and nightmare of probate. And ultimately, at the end of the day, it's really, truly a gift to the people that you love and that you leave behind. There's a big difference between either doing nothing at all, or maybe just having a basic will and then having to go through a full probate for a family, and having a binder of documents that's all very well organized and contact information for an attorney who's going to help them through the process, and it's going to be completely private outside of the court system. That's a way to show that you really cared, and just how much you loved your family to leave them with that kind of a gift.
Absolutely. That is really a gift. It's essentially, would you like to add to their suffering after you're gone, or would you like to alleviate some of their suffering after you're gone?
Yeah, I mean, if you think about it on a practical level, it's a time of grieving. It's a time of a lot of confusion, and nobody wants to have to go to court during that time. The best thing that people want to do is just be able to have things be easy, be experiencing ease and peace during an already very difficult time.
Right. And also, I mean, I also know that you also kind of mentioned this, but I think this is also something that's important to highlight. You know, actually, I watched the movie I Care a Lot over the weekend.
I
I
need
don't
to
know if
watch
you watched
that.
it.
I need to. Yeah.
It is a very good movie, and I will not necessarily give any spoilers, but essentially, having a trust and a full estate plan will avoid the situation that happened in I Care a Lot, right? Because it's essentially a woman, and she is a legal guardian appointed by the court for elderly people who don't have estate plans and don't have any sort of like they haven't appointed guardians, they haven't
Right.
appointed people to make decisions for them, and then she becomes essentially their legal guardian to do whatever she wants with their money and them and their lives.
Right. Yes.
And
So exactly.
and needless to say, this is not a spoiler, like she is not a good person, right?
Right.
In the movie. And of
Yeah.
course, you don't necessarily, I mean, a lot of legal guardians or court appointed guardians and trustees are wonderful people. On the other hand, if you have the ability to decide who you want to do that for you, you can avoid a situation like what happened in that movie.
That's exactly right. And that's one of the other benefits of doing your estate planning ahead of time, is that you decide ahead of time who the people would be, and you've already appointed them, to make decisions for you, to be a conservator over you if it ever comes to that, who would have access to your money and who would be able to take all actions on your behalf if you're not able to do that
Mhm.
for yourself. If you don't do that ahead of time, and then you do become incapacitated, and you're in a situation where, unfortunately, it sounds like a lot of the people in that movie were, then you are risking that the wrong person could potentially be appointed as conservator for you, or, for your money. And that's not a situation that anybody wants to be in. So it is equally as important to do your estate planning for future potential incapacity as it is for your certain to happen 100% certain death that will happen. We hope that we will not become incapacitated at some point in our lives, but the reality is that we don't know. We don't have crystal balls for the future. I'm a very positive, optimistic person. I think that I'm going to live a long, healthy life, to live to the ripe old age of 120. And I believe that all of my clients are going to be that as well. So we're not planning because we have a doomsday mentality. We're planning because we want to live our best lives now, knowing that we have taken the steps to ensure that no matter what happens, we're taken care of, our wishes will be honored, and our family will be taken care of, and we're not leaving a mess.
Yeah, absolutely. And I think the one phrase or the one line that I sometimes use with people when I talk to them about estate planning, I'm just like, everybody everybody has that one relative that they really don't like, right? Every single person, every family, everybody has it. I'm just like, I want you to think about that person. I want you to imagine your life with that person. Imagine all of the bad decisions and things you do that they do that you really don't um, agree with. And then I want to imagine that person making decisions for you and your stuff.
There you go. Yep, that's very true. It's up to a judge to decide. So we don't know what will happen if we don't plan ahead, because the judge has to decide, and the judge will not have the benefit of being able to talk to you to know what your preference would be. So you're
Exactly.
absolutely right on that. And I just want to talk a little bit about, so a lot of times people think, well, a trust, that sounds really intricate, sounds really expensive, sounds really complicated. I don't want anything too complicated. I want it to be very simple, but it's really not as complicated as it sounds. So a trust is, it's called a trust because it is built on trust, literally. So a trust is essentially an arrangement where one person gives their property to another person in trust, entrusting them to use that property and manage it and invest it or do whatever you've said with it for the benefit of what's called the beneficiary. So those are three people who are required to create a trust. And you could even have an oral trust, believe it or not. There's really not that many rules required to form a valid trust. Now, there are certain things that you're going to want to be in that trust, and that's why it's useful to work with a lawyer. But generally speaking, it's pretty straightforward. Now, when you're alive and well, you're all three of those people. You're the trustor, the person who created it. You're the trustee, the person you've entrusted with your own stuff. And you're the beneficiary, the person who's benefiting from it. So for all intents and purposes, during your lifetime, while you're alive and well and healthy, it's not going to seem any different to you than it ever was before. You still have full control, full access, full decision-making authority. The only difference really that you'll notice is that some of your assets, instead of being titled in your own name, are now going to be titled in the name of you as trustee of your living trust. And a living trust is also fully changeable, fully revocable, fully amendable. So it really doesn't change anything for you during your life. Unless you become incapacitated, then it is going to change something for you because you've done some planning ahead of time and you've named the person who takes over that role as trustee. Like I said, the successor trustee. You can name multiple people or people in succession so that you know that there's going to be someone available. And that's when things might change. You have a successor trustee step in, and now they're implementing the trust the way that you've said, but you're still the beneficiary if you're alive and well. And then what you do is you name who is the beneficiary after you pass away, then who is going to be the beneficiary of this stuff and who's going to be the trustee managing it. And when you have minor children in a home, a lot of times, people will name somebody to be the guardian of their children, their minor children in the event of their death. And then they'll name somebody else to be the trustee of their trust that's going to hold the assets that they've left for their children. And a lot of times the primary asset is really life insurance, because a lot of young families with minor children, they might have a home and they might have, some assets, but the primary asset that would be funded into this trust would likely be the death benefit from a life insurance policy if you've been smart and you've obtained life insurance to make sure that your children would be cared for in the event of your death. And so the people that you've named as guardians would be responsible for the care and the love of your children and making sure that they had all their needs met. And the trustee, who does not have to be the same person as the guardian, it can be, but doesn't have to be, is responsible for managing the money that you've left for your children. And the trustee and the guardian work together, and they create a budget for the care and the well-being of your children. And everybody works together to ensure that your children always have everything that they need.
Yeah, absolutely. And that's really excellent. That's really awesome. Um, and I think the last question that I have for you in terms of just like you talk about sort of a trustee and beneficiaries and all of that. I- Is there some benefit to having just a professional trustee instead of a family member? So like having your lawyer be the trustee or executor of the trust, or not executor, but like having a lawyer be the trustee, successor trustee, instead of, say, your children. If like Tom and Bob somehow get in a fight, like is there some benefit to having Alanna Pearl be the trustee?
Yeah, so that's a really good question. There's pros and cons, and I think this is a question that it's important to work with somebody who can really give you guidance on your particular situation, because there's no right or wrong answer for any one family. Having a professional trustee serve as a trustee of your trust, the benefit is that these people are professionals. They're licensed. It's actually a licensed profession in the state of California to serve as a fiduciary. And so in that way, you're going to know that this person's going to honor the terms of the trust. They're going to do things correctly. You're avoiding risk of dispute between family members if one family member is serving as trustee and the other family member doesn't like what they're doing as trustee. So in that way, it can be very beneficial. But then, of course, one of the downsides is that it costs money. And so, you have to pay the trust estate would pay the fees of the professional trustee. And so I would say that it's something certainly to consider for families who are setting up continuing trusts that will go on beyond your death, instead of just distributing the assets outright to the beneficiaries. And if you're just if it's a type of trust where the successor trustee has to do the administration, there's very specific things that have to happen when somebody dies and to administer the trust properly, and then distribute the assets to the beneficiaries. If you have a trusted family member who is, somebody who is detail oriented and is able to read legal documents with the help of a lawyer potentially, and is able to make good, sound professional decisions, then I think it's okay. Many families, it's very common to name a family member as successor trustee. But if you're setting up a trust, for example, one of the types of trusts that I set up a lot for my clients is something that we call a lifetime asset protection trust. And what it means is that instead of just gifting the assets outright to your children, either at a certain age, likely at age maybe 21 or 25, instead you keep the assets in trust for their entire life. And they have access, full use, and maybe they'll even become the trustee themselves at some point when you say that they can at a certain age or reaching a certain milestone. But until they become the trustee, sometimes in that situation where it's a trust that's going to be continuing on for the benefit of your beneficiaries, then you may consider having a professional who manages that, especially if there's a lot of assets, a real estate portfolio. You want to make sure that the right people are in charge and making decisions for that. Having a professional third party also provides asset protection. So if you're passing an estate, an inheritance to your children, and you want to do it in a way that those assets could never be taken away from them in the event of a divorce, a future divorce, or a lawsuit, or creditors, or any of the reasons that people lose money, then you're going to want to consider the possibility of having a third party trustee serve instead of your children as a trustee of their own trust, because it provides asset protection. And essentially that means that they don't own and control the assets, but they're available for their benefit. But because they don't own them and they don't control them, they also can't lose them. For example, a terrible divorce, which is a reason that a lot of people set up these types of trusts. They love their children, they even love their in-laws, their children's spouses, but their primary concern is, look, we've worked hard our whole lives. We've created this nest egg for our children and their children and our descendants. It's really important to us that these assets stay in our family and benefit our children and grandchildren. And of course, we're happy for them to benefit our children's spouses. But in the event of a divorce of, our son and daughter-in-law, we don't want our daughter-in-law taking half of the inheritance that we've left for our son. So that's a very big concern for people. And there is a way to set it up that's very reasonable, that's not overly arduous and overly complicated, but can really make sure that your children have the access that they want to the assets without risking them being lost to third parties. So that was a long-winded way of saying it depends. Sometimes it makes sense to have a third-party trustee, and sometimes it makes sense to have a family member.
Yeah. But what it does sound like having a third-party trustee is perhaps the safest option. And if you have a family member, it might intuitively be the easiest option, but there are certainly risks associated with that that are more than just money.
Yeah, absolutely. I think ensuring family harmony is a big concern. And so that is one of the things that I like to talk to my clients about when we're talking about who's going to serve as successor trustee, and making sure that they've thought these issues out, because sometimes it's really easy to say, oh yeah, my oldest child, that's the person. But, what if your oldest child and your other two children don't get along at all? And, essentially it's almost a guarantee that there will be disputes and fighting, and potentially even court, because if you have three children and they're all beneficiaries of your trust, and you name your oldest as trustee, and your other children don't like what that person is doing, what their sibling is doing, then they can file a lawsuit, and then you've basically created a situation that you were trying to avoid, which is people ending up in court. So it is a family, specific consideration. And like I said, there's pros and cons, but maybe rather than it even being a professional, it could be a trusted friend that would be appropriate for this role. So there's all different considerations, and anybody can serve as trustee who's over age 18 and an adult, and recommended to be somebody who's here in the United States. So there's a lot of different options available to families.
Yeah. Well, Alanna, I want to thank you for being here and talking to us about trusts and wills and estate plans and all of these really, amazing and important things that I think, people really don't think about them. Like, I think that it's really just something that somebody's like, oh, I'll get to it eventually. Or like, oh, I'm young, I don't own a house, I don't really need to think about this. And then something happens and it's like, oh, I really should have thought about this. Or, if you're not here, then your heirs are just like, I really wish, they had thought about this.
Absolutely. Yeah. Everybody
So
needs
I
to do
appreciate,
some estate planning, to be honest. Like, I'll just leave it at that. That'll be sort of my last piece of advice. Whether or not you have a huge estate or you're just getting started in your career, you need to have something in place. And that something could be something very simple, just deciding who would make decisions for you if you became incapacitated, and who would make healthcare decisions for you if you couldn't make them for yourself. And then all the way up to something very, very complicated involving asset protection and continuing trust for family members and everything in between. But everybody, the best time to do your estate planning was yesterday. The second best time is right now.
Awesome. Well, thank you so much, Alanna. And I mean, I worked with you and I know you, and I really do think that you're amazing and awesome and have great insight. But if people want to get a hold of you, what's the best way of doing that? And what's the best way
there's
for
a
people
couple
to get a hold
ways.
of you?
So you can go to my website. There's a way to contact me through the website. That's consciouslegal.law. My law firm is Conscious Legal ACP, and I had to learn how to spell conscious when I named my law firm that. So it's CONSCIOUS legal.law. So that's a website. You can also find me on Facebook, Conscious Legal. I have a Facebook page. You can send me a message there. And I'm always happy to have a 15-minute intro call with people just to find out more about your goals and desires when it comes to your estate planning and see if there's a way that we can work together to achieve them.
Excellent. Well, thank you so much. And also, I'll just add one more thing. You do also have a YouTube channel where you have really amazing and helpful videos as well. So anybody wanted to check that out, I assume if anybody wants to check that out, I assume it's also Conscious Legal on YouTube.
Yes, I believe so. Yes, I have to start putting a few more videos on there, but I do have one that's apparently going viral, which is exciting. It's like got 2,500
Yeah,
views or
exactly.
something. So yeah, four top legal Zoom mistakes when forming an LLC. So that's a topic for another day.
Yeah, a topic for another day, but there are many of them, I am sure.
Indeed.
All right. Well, thank you so much, Alanna. I will be here next week and have another really awesome guest. And I am actually really excited for the guest that I have scheduled for next week. And if you want to know who it is, you'll have to tune in to find out.
I'll tune in to find out.
Bye.
Bye-bye. Thank you.
Bye.